Thank you very much. Just checking you can hear me okay there? Excellent. Thanks very much. Thanks for that, Anne-Marie. My name's Ross Milvenan, so I'm an employment law solicitor at Digby Brown. And what I want to talk about this afternoon is returning to work, in particular in relation to employment law rights that you may have. I'm thinking here in particular about getting back to work following a head injury. And so we could move on to the first slide, please. That would be great. Thanks. I think we can probably just move straight on to the first one. Thank you. And so the aim of the next half an hour or so is really to provide an outline of legal rights that you may have. The focus here is really on disability discrimination that may occur during employment. So I want to focus on discrimination mainly because that's where the law offers the most protection to employees. We'll go on and have a look at the different aspects of discrimination and how this can occur. Needless to say, the law on discrimination is complex. It's ever changing. The law's constantly being updated through new cases that are decided, new points are taken, and as awareness of disability and general discrimination issues arises. It's time sensitive as well. It's one thing to point out, so that the time limits come around very quickly in relation to disability discrimination applied in a fairly brutal manner by courts and employment tribunals. What I want to do today is really provide an outline of the law and rather go into the complexity of it. And that's really just so that you're armed with the knowledge of employment law rights that may apply in the event that you have to use them. And if we can just move on, please, to the next slide. So what we're going to cover then will be firstly the definition of disability, because really that's key to it all. And also the types of discrimination that might occur, and how to actually deal with that. Some practical advice as to how to go about dealing with these points. And I also want to touch on something that's become topical recently with the COVID-19 and what's called the new normal. If we could move on to the next one, please. Now, what I've done here, I've sort of broken down the definition of disability, which is set out in the Equality Act in 2010. So just to read through the words that are on the slide there, so it can be quite important. So a disability in legal terms is a physical or a mental impairment. And then that impairment has a substantial and long-term adverse effect on the ability to carry out normal day-to-day activities. So that's the legal wording. There's quite a lot of reading, quite a lot of information within the definition. It is a legal issue rather than a medical one. Although clearly medical information plays a big part in whether an individual actually meets the definition. The important point about the definition is if a person meets it, if their impairment actually meets this criteria, then the law offers extra protection. And that's some of the points I want to have a look at here today. Before we move on though, just having a look at it and sort of breaking it down a wee bit more. So a physical or mental impairment. So a physical thing, could be literally an injury, for example, something that stops someone moving about. A mental impairment is clearly different, but no less important. And quite likely a brain injury, depending on the severity of it, may well come in to be termed a mental impairment in the way the law categorises that. What that impairment then has to have is a substantial and long-term adverse effect. What the courts have created rules for each part of this definition. So a substantial effect, it needs to be something more than trivial. It needs to be a real issue, and it's going to cause some issues in day-to-day life. Long-term adverse effect. The long-term part of it has been held to be by our courts a condition that lasts for 12 months at least, or it's likely to last for that period of time. It's not a hard and fast rule. That's a general guide that the courts work to. And it needs to have this adverse effect on the ability to carry out normal day-to-day activities. So that could be anything, literally from going to work, getting in there, anything that any help you might need if your impairment affects your work or anything else you may need to do. So if we could move on to the next one, please. What we're going to do here is just have a look at different types of disability discrimination. You see them on the screen here, can be direct or indirect, duty to make reasonable adjustments. It also protects against harassment and victimisation where that occurs. What all of this is really, these are just labels and labels that the law puts on to categorise different types of behaviour. But all effectively come back to being disability discrimination and preventing that. That's the whole theory behind the Equality Act provision. So if you meet the definition, you're protected against each type of behaviour. And if we can move on to the next slide, please. What we're going to do is go through and explain, give a bit of an outline in relation to each type. Now, direct discrimination is the first one that we have here. So this is where you, let's say, as an employee, if you are treated less favourably than someone else at work, and that if you're treated less favourably because of a condition that's a disability, and that's known as direct discrimination. So being treated less favourably could be any treatment, but it has to be because. So the employer is, in this case, treating you in a particular way because you have this disabled condition. There can be no justification for that. The law says no, employers are just simply not allowed to do that. It's literally, it is outlawed. So it needs less favourable treatment. You have to be treated less favourably than someone else. You need to actually compare yourself against someone else, someone who doesn't have a disabled condition, and explain you've been treated in that way. The law does, however, allow positive treatment. So someone who has a disabled condition can be treated more favourably than someone else. But what's unlawful is the less favourable treatment. Now, you mentioned a case on the slide here, a case of Cordell and the Foreign and Commonwealth Office. The reason I mentioned this here, what I want to do is just use this as an example of the type of behaviour that might have been direct discrimination. So it's really to use that as an example rather than look at a sort of legal analysis of the background to it. Now, Mrs. Cordell, she worked for the Foreign and Commonwealth Office, and she was posted abroad. I think she'd been doing very well there, and she was promoted into a new job, which meant going off to a new country. She'd be off to do a different job, promoted job in Romania. She was deaf. The Commonwealth Office knew about that, and they made adjustments. And she had lip speakers that would help out with her work, and all that worked fine. What happened here was when she was being risk assessed for the new post, and before she actually went off to carry it out, the employer here looked at the cost of having lip readers or lip speakers to help her out, and it was going to be a 3-year posting. What they come up with was that the cost would be over £1 million for the period she was going to be out there. It seems quite surprising. I'm not sure how they managed to justify that, but they obviously must have presented some information that supported that. So they said because of the cost, the employer said, no, we're not, you're not going to go off into that promoted role, and she couldn't take it up. So she quite rightly said, no, I feel I've been subject to discrimination here, and she pursued a legal claim because of that. Ultimately, what happened is she had to compare herself, so she's been treated less favourably. She hasn't got the new job, and that's because of her condition. Because of the condition, she needs the assistance. What she did was she compared herself against other employees in Foreign and Commonwealth Office who were provided with an education allowance. So if someone's moving to a new country, the employer had a policy where they would pay for children to be educated there in certain circumstances. So she compared the cost would be for the lip readers to the cost for cost for children to be educated. So a couple or an employee who had a few children, the cost could be similar to educating them abroad. So she said that was she'd been treated less favourably than them. The court, however, found it wasn't direct discrimination in this particular case. What they did was they had to analyse the actual detail of the particular circumstances here. And they found that the reason for Mrs. Cordell having not been appointed to the role was not her disability, but it was the cost. And that was the deciding factor. So it was the cost of the adjustments they were going to have to make. That meant that she wasn't then treated less favourably. So that particular example, that hasn't worked out for her. If the cost hadn't been quite so high and she had been rejected for the role because of her disabled condition, then it may well have been less favourable treatment. But in this case, it turned on that particular fact in there. So it's a bit of an illustration of behaviour that could potentially be discriminatory in a direct way. Can we move on to the next slide, please? The next one I want to have a look at is, again, a different category of discrimination. This time it's the label the law applies to this is discrimination that arises from disability. So this is a little bit different. Again, it's almost splits hairs between the different types of discrimination. Here, this is where someone is treated unfavourably. Last one was less favourably. This is unfavourably. So treated unfavourably because of something that arises in consequence of a disability. So slightly different here. The main difference here is that you then don't have to compare yourself against someone else. You're not being treated less favourably than someone else. You're just being treated unfavourably. An unfavourable treatment could be anything. Really, it's not defined. An employer can defend that though. They can say, well, an employee complains of unfavourable treatment because of a disability. They can say, well, we can justify that because we've got a good reason, basically, for it. So again, that depends on an analysis of the circumstances. Quite often, I find this type of what becomes a legal case, the unfavourable treatment, comes from something that arises in consequence of disability. Very often this can be absences. So if an employee has disability-related absences and they are, say, subject to some form of sanction, or sometimes disciplinary proceedings because of that, they have warnings, ultimately could be dismissed, and that could be unfavourable treatment if those absences related to disability. So there's extra protection there. An example of this was in a case in Land Registry versus Houghton and others. So this was a group of cases that was brought against the Land Registry. And this is where there were a number of employees who were denied a bonus payment, and that was because of absences, because of disability-related absences. So each of the people who pursued the claim had been absent. They all had a disabled condition. And it'd been through a series of warnings and the adjustments had been made, I think. But ultimately, they didn't get a bonus because their absence levels high. They said, well, we've been treated unfavourably because of that. We can't help these absences. We've got good reasons for it. That's all been supported. And we all meet the Equality Act's definition of disability. So not get the bonus was the unfavourable treatment. And the court found that was unfavourable treatment, and what the employer's practice here was discrimination. They should have been offered an opportunity to have the bonus, basically. So it was found that was unfavourable treatment on that occasion. This one we want to have a look at is indirect discrimination. So again, this is slightly different, a different category, a different legal category of discrimination. And really, this is where the employer has a rule. If they have some sort of particular rule, and that then has it's people who have a disabled condition, a substantial disadvantage, then that can be discrimination. Rather than being actual behaviour, people saying things or absences or this type of thing. This is some rule. So if there's a particular rule in there, so paraphrase the legal words here, but so it could be a practice. If it's a certain way of doing things, could be an employer's policy. Something that's literally written down, like a disability, like a absence policy, or a disciplinary policy, or that type of thing. If the policy applies to everyone, but puts a certain group of people, a disabled condition, at a substantial disadvantage in some way, then that can be discrimination. So often this can happen without the employer actually realising it. So it's quite important to monitor the effects that the rules that an employer might have can have on people, even if they don't intend it. An employer can justify these things here if they have basically a good reason for that. One example we want to look at is a case that came from the European Court of Justice, which is a case of Oder. You can see a German case. Now, what happened here was Mr. Oder, he had a disabled condition. In Germany, he was made redundant. And the way the rules worked in Germany, whether you were, they applied the age of 55 as being a sort of threshold for receiving a redundancy payment, and you got less of a payment if you were over 55, effectively. So he said, well, that's discriminatory to me. I'm receiving less money than I would, firstly, if I was younger, so an age discrimination case as well. He also said, so this policy here, this rule that's been applied, means that I would have received twice the amount if my age was different. So you said that the policy was an example of indirect discrimination, and he won his case. And what the court found, and he had to go all the way to the European Court of Justice to get a decision on this, is that it basically found that paying a worker who was severely disabled less than those that don't have that disabled condition is indirectly discriminatory against them. So it was that policy that was wrong. They hadn't perhaps intended that effect, but did have it was discrimination towards Mr. Oder in that case. Now, next thing we'll have a look at then is what are called reasonable adjustments. So reasonable adjustments, this very often applies, and I've come across this a lot in clients who have brain injuries. So again, if you or someone else meets the definition of disability, if you can tick the boxes in that criteria, what that does automatically is place a duty on an employer to make what are known as reasonable adjustments. So that could be anything. So it needs to be the employer has a duty to make changes to stop that employee and put it at a substantial disadvantage because of their impairment. So reasonable adjustment could be anything. And literally you would have the right, if you met the criteria, to make a request. This could be adjustments to, say, it could be physical adjustments to premises. If someone was, for example, physically disabled and they're getting into the premises, the employer's workplace, involved huge numbers of stairs, and there was no other way to get in there, and that was an issue. And potentially that could be an adjustment. You could ask for a way to access that, or perhaps a different way of working. So it could be a physical thing. Could also be to working practices as well. So a person who meets the criteria could, for example, ask to work less hours. It could be one example of that. If they say they have medical advice not to work, for example, take 12-hour shifts, but for long shifts, condition that leads to fatigue, then they can ask the employer, right, well, I need my working practice to be changed here, and I need to work, say, half that time, or need to have regular breaks, or whatever it was that the medical advice supported. So again, it really comes down to what's reasonable in the particular circumstances. If the employer fails to comply with that, then potentially that could be an act of discrimination. Where the legal battleground tends to arise in these type of cases is whether what's reasonable or not. So cost, as we saw an example in an earlier case there, but in that case, costs, it shouldn't be an overriding factor, but it can be a factor. In the Foreign Commonwealth Office case, it was also a case of reasonable adjustments as well. Cost can come into it, but it certainly doesn't make the decision. So the duty arises in different ways. Could even be a policy of the employer. If you need to have an adjustment to a policy, say there's a absence management policy or a disciplinary policy, you need extra time because of a disabled condition to comply with it. Say make representations during the process, and they can ask for that, and the employer has a duty to make those adjustments. So that's generally how these things come around. The aim is really to stop the impairment having a substantial disadvantage when you compare with someone who doesn't have a disabled condition. That's reasonable adjustments. I want to also just have a look at different types of behaviour which may arise. Harassment being one of those. So harassment can happen where there's really some sort of nasty behaviour that happens during the course of work. So it's unwanted conduct is the way the law describes that. It has to be something that's related to disability. So comments made, horrible comments or anything else to that effect, almost like bullying type behaviour. If that has the effect, you can see the legal wording there, really creating just a horrible, intimidating atmosphere. Then that conduct, if that happened, that could be proved, and that would be an example of harassment. And obviously, the law protects against that. The next one is victimisation. To look at this, so again, this is extra protection for anyone who meets the criteria. So this is slightly different, but again, it's about people's behaviour. So if you are subject to some sort of detriment, and that could be anything, some sort of unfavourable treatment, because you've taken some action that relates to disability discrimination, then you're prevented against that. So this could be if you say had pursued a legal claim, a tribunal or a court claim that relates to discrimination in some way, it applies to any type of discrimination, and you then are subject to some unfavourable treatment. You're pushed out of your job, your pay was altered, this type of thing, then you're protected against that. And the same thing happens if you'd given evidence in a case that involved discrimination. The employer then cheated you, put you to some detriment because of that. Then that would be unlawful. You're protected against that. Now, what I want to do is just move on to some examples of what sort of action you could take if this type of thing came about. So the focus there is really on being worst case scenarios, or the type of cases you could pursue if you had to. Really, what the law is all about is preventing that behaviour. The law's there, these rules are there, so this type of behaviour doesn't happen. Unfortunately, sometimes it does. What could you do? How can you actually help yourself here? So if you're someone, so you meet the criteria, you have that right to request reasonable adjustments. So again, that can be anything. Anything that you need to prevent yourself being put at a disadvantage. So if it's head injury, if it's adjustments to working hours, or literally your display equipment, if you're working with monitors or computers, etc., then fine, you can ask for all of that. What the law requires, and again, this is really just a practical thing. The best way to try and resolve these things is to do it informally. First of all, so literally, having a chat with a lawyer, or manager, or whoever it is, and explain what's going on. I find that some employers will listen to that and might be aware of issues that might come up, and they'll be accommodating for that. Others, for whatever reason, and it generally comes down to the attitude of individuals, I certainly find, will just put up barriers to that, and will just put their heads in the sand, saying, I don't want to deal with it, focused on work or whatever else, and they don't want to do that. Well, obviously that is not good enough. we need to try and resolve these things informally. If that's not going to work, if we come up against a difficult attitude, there's a right to submit a grievance. So that's just a legal term for a formal complaint, basically. Submit that to the employer. They've then got a duty to take that on board, come up with an outcome to the complaint, a way of preventing this treatment. None of these things work, and you do have to pursue a legal case. In cases of discrimination at work, would go to an employment tribunal ordinarily. So again, that's, I suppose, worst case scenario, but that right is there. And it applies no matter how long you've been employed by an employer. Even would apply to a job application process, even if you were employed. One point just to mention, I said at the start, the time limits are really quick. The laws is constantly changing. If someone was having to lodge a claim, you need to do it quickly. And the time limit is 3 months, 3 months less a day from the date of an act of discrimination taking place. So just to mention that. Now, if we can move on to something slightly different, before we come to questions, I just want to touch on the terms now, the new normal. This in light of the whole coronavirus pandemic. I'm not sure how long it has to be normal for before it stops becoming new, but things go on. I expect we're probably getting towards that. But really, just to think about some of the considerations that might come up in the present world that we're living in. Shielding is one of these new terms that we're all becoming used to. Shielding, I'm sure everyone would be aware, really if you're having to stay indoors and avoid as much contact as possible because of a medical condition, how that then impacts on work and perhaps returning to work, it can be difficult. And employment law really doesn't necessarily help out here. The law changed just at the beginning of last month in relation to pay, and pay is really where shielding can become difficult for people. In that, there's now no right to receive statutory sick pay if someone is actually shielding or having to stay at home, so you don't minimise the risk of catching COVID-19. So clearly that's not going to help many people out here who have to do that. If, however, you're sick, if you're sick and having to shield, then you can certainly are eligible to receive at least statutory sick pay, or perhaps if there's maybe better contractual terms an employer would have. The thing to be wary of here with shielding is falling into what really is the danger zone of saying to the employer, I'm not coming to work because I have to shield. The reason for that is implied in every employment law contract is that firstly that the employer must provide work, there's a duty to do that, but the employee must carry out as well. So if you say, right, I can't, potentially if I can't come into work because I'm shielding, then potentially you're refusing to go into work, refusing to carry out the work, then there's no right to be paid. That's the danger area to stay away from. There's no real legal answer to that, unfortunately. The law's still to develop in that area. What you can do, though, is try and help yourself out. So returning to work, that can involve practical measures. How do you actually, is there a way to get back to avoid that? Can I work at home if that's possible? It's not always possible, but that might be one way around it. Or are there extra measures the employer can actually put in place, practical things, working hours or anything else that might help. So really the answer and all the guidance in this point is to try and come up with a way to avoid saying no, I can't come in, then not being paid. So it's all about being flexible, and it needs the employers to agree to these things. To touch on that, some current considerations. Really, in summary then, lots of different. I think the point to take away from it is that the law offers protection. So that you don't have to do that. Use these things positively. It's good to be armed with the knowledge of these things as we can prevent these situations coming up. However, if there's any issue with it, employers being difficult or whatever else, and certainly it's important to take advice on these points. Now, last thing I just want to mention, so on the next slide, is some resources. If you want to have a further look at this type of thing, it's possible to move on to the next slide, please. That would be grand. So a few different places you can find out some more information. ACAS website, the address is up there. That's just awash with helpful information, helpful employment law information, both employees and for employers. And there are lots of guides on there that set out certain rights that people have. So certainly that's a certainly good source of information. I've mentioned as well, ACAS, there's a YouTube guide on there if you're looking for a visual thing. Also, if you need to take advice, then we have our own email address up there in the event that was needed. So I think that's really all I wanted to mention for now. So if there's any questions, happy to help out with that.
Hi, Ross. Thank you so much for that. It was so informative. I have two questions, but they were asked quite early on, so you may have already answered them, but I'll have a go at it. So this question's from Nicole, and it's, does my employer have to allow me to return to work after my brain injury?
Yeah, if you're fit to return to work, then yes, should be allowed to come back. Sometimes it needs to actually look at all the specific circumstances. So yeah, there are, if you're not fit to go back to work into the long term, potentially no, they don't have to. An employer might ask about that. They might ask about medical information and have a process for that. But what the law does is it really strikes a balance between the need for the employee to get better, time for that, and the need for the employer to get work done. So there's a balance there. Easier for larger employers to accommodate these things, but so sometimes it can be more difficult for smaller employees. But yeah, it really depends on that and recovery and what type of work can be carried out. So medical evidence or medical advice is the best way to go with that. Get some guidance.
Well, I think you've kind of answered the second question that I've got from Jacqueline, and it's what if I am unable to carry out my original job? Should my employer find me an alternative role?
Yes, well, you've certainly got the right to ask for that, and that would come back, I think, to reasonable adjustments. So the employer's got a duty to consider that. So if it's a case of coming back to work and you can't do hours, or there's a particular task you couldn't carry out, you've got the right to request that and ask for adjustments. And it's then for the employer to decide if it's reasonable or not and can be accommodated. And if not, if they're being unreasonable about it, potentially there's a challenge there. But there's that right to make the request.
That's fabulous. That's great. Thanks so much for your time today, Ross. And I'm going to move swiftly on to our next speaker.